Morning. Today is Tuesday, the 16th of April, 2024. My name is Craig Call. I'm the Land Use Appeals Hearing Officer for Grand County, and we are here considering an appeal from a decision by the County Commission to deny a conditional use for Escape Adventures. This matter was noticed, and I just have a couple of preliminary items to cover. First of all, let me say on the record that I have no information about this case except what I've heard in a series of email exchanges that are public documents and part of the record. The parties met this morning at 9 o'clock at 4330 Easy Street to observe the location of the appeal, the property involved, and also to get a general sense of the neighborhood, since those are specific issues that I need to consider in a conditional use matter. So let me mention that I am an attorney. I've had some experience in land use, and perform this service for other communities. I have worked with Grand County in this position for 3 years. I guess it's been 2021. Most recent contract renewal, I think. So let me first ask those present just a couple of guidelines. If a person wishes to speak, I want to make sure they introduce themselves on the record and that I know how to spell their name correctly. Everything is being recorded. Everything's part of the record of the decision. And we've done this in a way so that anyone who wants to review the decision after it's made will have the opportunity to be exposed to every bit of information that I've had access to, so that it's meant to be transparent exactly what information was provided. So my first question is whether anyone here objects to the appeal being filed to my jurisdiction and hearing the appeal in the notices that were provided, or any other concern about the format of this appeal. Any objections or concerns there? Seeing none. The next issue is the nature of the appeal. When you read the Grand County Appeal Authority ordinance, it talks about the hearing officer and what the duties are. Let me read that more specifically. I can find it here quickly. So the powers and duties of the hearing officer are to hear and decide appeals where it's alleged there's an error in any order, requirement, decision, or determination made by the administrative board or official in enforcing the ordinance. I'm in County Code Section 8.2.4A. Then it says, every decision of the hearing officer should be subject to review by the 7th Judicial District Court. An appeal can be taken by any person aggrieved by a decision and within the time provided. The issue here is that there is nothing in the appeal authority ordinance that clearly designates what the standard of review is. So in an email exchange earlier, and by consulting the state statute, the determination has been made that I would hear the matter de novo. What that means is de novo, the Latin phrase for at new. So I will consider the record that was before the county commission, and I have reviewed it. I've reviewed the staff report and have also observed the YouTube broadcasts of both commission hearings where motions were made. I didn't review the broadcast of any public hearings that were held, but I did review the 104-page report, including all the written materials that were submitted, and the two Grand County Commission meetings, at least the segments where this issue was considered. That being said, I have the fortunate or unfortunate duty to make a decision. And by doing it de novo, what that means is that my decision would have to be appealed directly to the district court. There will be no remand back to the county commission. And there has been some confusion about that. If this were a record review, if basically the county commission had adopted an ordinance saying that the review was on the record, then I would simply look at what the county commission had before it, take no new public testimony other than to point out information in the record that's there already that I should consider. And my role would be to decide whether or not the commission had substantial evidence in that record to support its decision. If it did, I would confirm the decision. If it did not, I would remand it back to them to make a decision based on the record and create a record for their decision. The basic background for this is a Moab case that was decided not long ago, for I guess it was 6 years ago, coming on, McElhaney v. Moab, where the Moab City Council made a decision without creating enough of a record to support its decision, and the Utah Supreme Court remanded it back to the city of Moab to reconsider and establish a record. So anyway, from my understanding and from the email exchange I had with the parties and the county attorney before, the decision was made to proceed de novo. Any question or concern about that? I'm just trying to stir up trouble and nobody wants to take the bait. So. Okay. It also wasn't clear from the county ordinances whether the public would participate in this process. But again, the parties talked about it and decided there was no reason not to have the public involved. The main reason being that the county ordinance seems to be almost clear on the subject, and the commission allowed the public comment, and so there's no reason not to do that in the interest of not just the appearance but the substance of fairness. That said, we did have a motion to intervene, and that's an interesting issue that I'm glad we get to sidetrack. In another case involving Southeast Utah, the case of Northern Monticello Alliance versus San Juan County, the Supreme Court created what I consider to be some fairly complicated rules about who has the right to present evidence in a hearing. A simple land use appeal, which that was. It involved the wind turbines around Monticello and the neighbors who were concerned about the turbines. The turbines had been built based on a conditional use permit, and the neighbors wanted the conditional use permit revoked or amended at least because they said the property owner hadn't complied. And the planning commission heard information. They made a decision not to revoke the conditional use. It was appealed to the San Juan County Commission. And I'm not a fan of having elected officials serve as an official appeal authority, just for what it's worth. But the San Juan County Commission then took new evidence and decided not to revoke the conditional use permit. This case went to the Court of Appeals twice and the Supreme Court once so far. And the decision was that even though the property owners had standing to bring an appeal, they didn't have the right to provide any evidence at the hearing. I'm shaking my head in some disbelief, but that's what the court ruled. So thanks for letting me sidestep that whole issue by making this a public matter. Sorry to get off on a tangent. Okay, I think I've covered the details. The substance of this issue is basically a conditional use permit, and I'd like to just take a moment, based on the information I've read and the public comments already received, in the interest of efficiency, let me just share this context that I think I'm pretty well obligated to comply with. So this is the county land use statute in state law. It says the county may adopt a land use ordinance that includes conditional uses and provisions for conditional uses that require compliance with the objective standards set forth in an applicable ordinance. If I may go on another tangent for a minute, thanks to the county for the standards of the ordinance. There are, clear standards provided for in the ordinance, and I appreciate those who incorporated those in the county land use code. A lot of jurisdictions don't have that, and I'm pleased to be able to work with that here. Then the state statute goes on to say a county may not impose a requirement or standard on a conditional use that conflicts with the provision of this chapter or other state or federal law. And then it says a land use authority, which is me at the moment, shall approve a conditional use if reasonable conditions are proposed or can be imposed to mitigate the reasonably anticipated detrimental effects of the proposed use in accordance with applicable standards. This requirement, I'm paraphrasing, to reasonably mitigate anticipated detrimental effects of the proposed conditional use does not require elimination of the detrimental effects. If a land use authority proposes reasonable conditions on a proposed conditional use, the land use authority shall ensure that the conditions are stated in the record and reasonably relate to mitigating the anticipated detrimental effects of the proposed use. Then it says, if the reasonably anticipated detrimental effects of a proposed conditional use cannot be substantially mitigated by the proposal or the imposition of reasonable conditions to achieve compliance with applicable standards, the land use authority may deny the conditional use. And the rest of this is not particularly relevant. So that's the context in which I'm operating here. So basically, we're narrowing it down to a few questions, and they include: what are the reasonably anticipated detrimental effects of this proposed use, and can they be mitigated by reasonable conditions? So that said, let me just mention briefly thought I had a note there. What I've gleaned from the information in the record already. Concerns have been expressed about hours and noise and lighting, traffic. There was work on a vehicle that needed to be repaired. The appearance of an 8-foot wall. The 8-foot wall's impacts on the neighborhood and its consistency with current improvements in the neighborhood. Loading and unloading at odd hours. There was a lot of general discussion about introducing this commercial use into an area that doesn't have a commercial use on that property, at least not a legal one at this time. Visitors, hours, the number of employees. Basically, that's kind of a really broad overview of what I gained that I thought was most relevant to the conversation today. So anyway, I'm about to get out of the way here. I wonder if anyone would like to speak to the issue. Usually, since the applicant bears the burden of proof in a case like this, I'd let the applicant speak if they wish to. But certainly the county and anyone else is welcome to comment. There aren't a lot of people here, and I don't object to this being somewhat conversational. so that it doesn't have to be any more formal than it needs to be. So does the applicant wish to offer any information at this point?
Yes, I would. My name's Merrick Goals. I'm representing Escape Adventures. I'm also the GM of Escape Adventures and I've worked for them for 20 years living here in Moab. I feel that our application, we have shown that we do fall within the parameters of what the county requires for a CUP, and that this is an okay location for that, a perfectly fine location, given that they've already granted ECB Farms the CUP on the same street. We're a small operation. We don't create a lot of noise. We don't have big lights out there, big loud trucks. We don't have that many employees. Sorry, this has all been a learning experience for me, talking publicly and on official matters. I'm sure I'll have more to say as this goes on. But in short, I feel that we have done our due diligence in making sure that all impacts on the neighborhood would be mitigated. Thank you.
Thank you, appreciate it. Does the county have a comment?
So first, we'd like to know there has been a motion to intervene, and
This is Stephen Stock.
no, I'm sorry. My name is Stephen Stocks. I'm the county attorney. I would note that there has been interest from the neighbors. They are represented by Ms. Sloan. She's provided documentation. I just want to confirm that that's some of the information that the hearing officer has received and reviewed. Next, really the conversation for conditional use permits, we're going to be looking at 9.10.5 A through F. And realistically, the county likes to focus on, or would like to focus on, the effect on the environment, compatibility with the surrounding areas. First and foremost, the area that where this proposed conditional use permit would be is in a substantially residential area. It's a quiet area. That neighborhood does not have a lot of commercial vehicles. The lot sizes are large, houses are set back in a way that highlights and emphasizes the rural beauty and the tranquility and quietness. And so when we look at this application, what we're looking at is an ability for essentially a business to exist in that area. And the trouble and the difficulty that we have is mitigating the impacts that we have. And I don't think we can mitigate many of those impacts. Number one, the noise. This morning when we were out there, we could hear birds chirping and it was exceptionally quiet. What has been continuously raised and was really considered during the commission's review of it was there are individuals that were going to be loading these vehicles. It's going to be rigging and de-rigging for this commercial venture. That's loud. It would include packing, unpacking at earlier hours, and that's something that we can't eliminate entirely. But I don't think that we can mitigate it to the point that it would allow for peaceful enjoyment of the property, and that's 9.10.5A. That's one of the major concerns. Is we don't have an ability to mitigate that to the point where the neighborhood is going to continue to maintain what it is. And that shifts into item B, compatible with the surrounding area. Where we're at in that neighborhood is we're at a place where there's not a lot of commercial activity. ECB Farms is on the same street, that's true, but it doesn't have the amount of in and out that a normal business would have. Instead, what it's been represented to us is it's a farm stand that's unmanned that doesn't create additional traffic. With that, we can't having that be a part of the neighborhood. It doesn't really fit. We're going to have a proposed parking, and again, in the application, it noted a 20 vehicle parking lot. That's substantial. We have additional residences near the area, and to have that many vehicles, I don't know that it's feasible for that road that is essentially a dirt road for it to exist. Not only does that create noise, but it also kicks up dirt and creates more traffic. Next, we don't know if individuals are going to be coming, individual customers are going to be coming out there. While we can make some mitigations to that, we don't want to highlight, we don't want to encourage individuals utilizing residential areas to create a business. Now, that's something that can't be mitigated to the point where, again, we're going to have that peaceful enjoyment of the property, and it's really not compatible with the surrounding area. Next, fencing. We have an impact on what we're going to be building there. Now, we have a 6-foot fence there. They'd like to increase it to an 8-foot fence, but the fencing alone isn't going to mitigate the level of sound. We have a lot of open space. Sound is vibrations. Vibrations travel through the open space at a greater length and without additional blocking or not even screening is going to do it to cover the amount of noise that is going to reverberate out to this community. So those are the major issues that the county would like to note and point out at the onset as kind of the major issues. Apart from that, as Mr. Call, you've noted, don't know the hours. Some of the other minor issues, I do think there is a possibility of mitigating to an extent. One could restrict the hours. One could restrict some of the other items, but I don't think that there can be a reasonable mitigation of the noise, the traffic, the fence, and essentially the wide-scale commercial activity. So that's where the county would start off.
May I address those concerns individually?
Guess I'd prefer to have you respond to the comments after we hear from the public.
Fantastic.
But again, somewhat conversational. I don't mean to cut anybody off.
And Mr. Ball, if you have any questions specifically on the position of the county, I'm happy to elaborate on.
Thank you. Appreciate that. Is there anyone from the public who'd like to comment? Yes, please.
My name is Christina Sloan. I'm a local attorney and I represent two neighbors, Doug Carroll, who owns the adjacent property located at 4346 Easy Street, as well as an adjacent property owner, Eric Flume, who is just, southwest of this property at 4318 Chapman Lane. Mr. Flume's home is a 2-story house that overlooks this property. And Doug Carroll owns not just the immediately adjoining property, I should clarify, but he also owns fields that surround this property on the east and south sides. They also participated in the original process before the county. I do not want to repeat what Mr. Stocks said, but I do want to pick up a couple of things on those same criteria sections. So he referenced subsection A of 9.10.5, which is effect on the environment. That section references impacts that are detrimental to the health, welfare, and safety of the surrounding neighborhood. This is something we discuss at length at the site visit. So, Mr. Call, do you want me to repeat some of those arguments about the different roadway standards and the fact that every single street getting to this property is not built to county standard, or is the information from the site visit sufficient? How would you like me to handle that?
If you want to make sure that's preserved for the record, please do it. Go over it again.
So safety is a big concern with this conditional use permit. Spanish Valley Drive is a major collector road in the county. This property can only be accessed by local roads, and that is Heaven Lane, I believe, Heaven on the southwest side of Easy Street, or Chapman Lane, or sorry, that's the north side, or Chapman Lane located on the south side, and both intersect with Easy Street. These are local roads by the Grand County construction standards, which I do cite to the particular subsections there in my letter, which is dated April 4th. But what's important to know is there are certain standards to which these local roads are supposed to have been built, and they are not currently built to standard. All three roads are substandardly constructed and maintained at this point. The issues there is there's supposed to be 20 feet of asphalt. There's not. We were on the property or on the roadway today, and there's maybe about 12 feet of asphalt there. The lanes are supposed to be striped. They are not. There's no yellow striping down the middle of that roadway. There's supposed to be shoulders. There are not. There's supposed to be certain slopage away from the asphalt surface. There is not. There's supposed to be curb and gutter. There is not. These are issues that in theory could be mitigated by requiring applicant to improve the roadway to these standards, but that is financially not feasible. We're talking about probably a $500,000 to $700,000 construction project. The applicant would have to bear the cost to keep those roads safe. And why it matters is this property is located in the middle of an existing residential neighborhood called All American Acres, which is one of our oldest subdivisions in the unincorporated county. There are two newer but existing subdivisions that border All American Acres, also on the east side of Spanish Valley Drive, and those are Vista Antigua and also White Horse subdivision. So you have numerous high quality, low density residential properties in this area. You have a lot of families and kids who use those streets to ride bikes, play ball, do all those things we want our kids doing. These streets are also used not just by all three of those subdivisions on the east side of Spanish Valley Drive for hiking to access the Red Rock that we looked at today at our site visit, but also neighborhoods that are across Spanish Valley Drive on the west side. There's a lot of folks that access this area for hiking along the roadway. In addition, there's large equestrian properties all through the unincorporated county in this area, but specifically at the end of these streets, at the end of Heaven, there's an equestrian park property there where many people board their horses, and those there's an equestrian trailhead that's located essentially across the street from, well, it's Doug Carroll's property, but the adjoining property at the intersection of Easy and Chapman. So you get a lot of what I'd call recreational uses, but by the neighborhood that supports the high quality nature of this area. So safety is a big issue I wanted to bring up. Stephen touched on subsection B, compatibility with surrounding area. I think you got a really good sense today of what the surrounding area is. The land use code criteria specifically references scale, height, screening, building coverage, and density. And these are all very important when looking at this. A 6-foot fence is the highest fence that's permitted in residential zones. That is completely inadequate to screen this property, or sorry, screen the uses proposed on this property. At the same time, you experienced this morning that all of the neighboring properties have open fencing. The fencing that is on this property is unique already, and that is a 6-foot fence that surrounds portions of the property, not the entirety of the property. But certainly trying to fence out the entire use, even with a 6-foot fence, is incompatible with the neighborhood, arguably, but certainly the proposed 8-foot fence that the applicant proposed in site plan is would need special permission for one, but it's also incompatible. It also would not block out noise, whether it's 6 feet or 8 feet, the noise always rises up, and we're in the desert. So this noise has nowhere to go but into the people's homes. We looked at the surrounding neighborhoods that are largely built out, all of the surrounding lots with homes. There is a home on the northwest side that is quite close. We did not measure it, but I would have estimated that's maybe 20 feet away or so from the proposed parking lot location. You also have my client, Mr. Eric Plume, who's on that back line with this 2-story home that you could see from where we were standing, and whether that fence is 6 or 8 feet, both of those homes in particular are going to be able to both see into the 20 spot parking lot, but also hear all the noise. I also want to touch on another subsection of the criteria that Mr. Stocks did not, and that is subsection E, consistency with the land use code and the general plan. I think this one's really important. The county just recently in 2022 amended and restated, adopted a new general plan, and it's got a lot of really good help here. What you see in the general plan is a very recent confirmation that we want to encourage and continue to support agricultural uses, high quality, low residential uses in the unincorporated county. And, these quiet spaces as well. The general plan does reference some commercial nodes that that there's some intent on potentially encouraging into the future. But what's super important about the commercial nodes they talk about, and they call them both commercial nodes and neighborhood nodes, is that they are all along our major collector streets for one. So that would be Spanish Valley Drive in particular in this area. That's the only major collector road in this area that would be appropriate. There are others in other areas of the unincorporated county, but here we're talking about Spanish Valley Drive. All commercial activity anticipated by the general plan in this rural residential area would be on Spanish Valley Drive. And importantly, they need to service the neighborhoods. That's the point. So all of the commercial uses envisioned into the future out in this area would be a small grocer, would be a daycare, would be these type of services that provide services to the neighborhood so they don't got to commute to town to grab some bread, right? And this is something that's very, very different than that. I do want to touch on the mitigation issue a bit more as well. This CUP, the proposed uses cannot be mitigated here based on the very nature of the business. The business is vehicle based and it uses commercial vehicles. The property will be used solely for business. The business doesn't even have an employee living on site. There is another home on that property and it is being leased to an employee in the county. So this isn't, a small use that's incidental to the primary use of residential habitation on this property. This is strictly commercial. It's very important. And because of the vehicle-based nature of this business, you cannot mitigate some of the main issues that Mr. Stocks talked about, which is the vehicle traffic and noise. And of course, when you're talking about vehicle traffic and noise, you're also talking about fumes, odor, and glare, and all of those issues are discussed in the CUP criteria as well. Already talked about the fact that you can't mitigate the safety concerns based on the financial cost of improving those roadways to local standards, but you certainly should not have a business of this type in that neighborhood without doing so. The fencing, not only is fencing out the entire parking lot incompatible, but how can you do that in a way that would be noise proof and also look okay? A wood fence is not noise proof in any way, and you can't mitigate with a fence in this point. And then the other issue is enforcement. It's not enough that the county could impose certain conditions and could do an annual review and could possibly enforce violations in the future. The county doesn't have the resources to do it. It took the county 2 years after numerous complaints from both neighbors and commissioners about this issue for us to even get here. We don't, and that's not a judgment on county. I know how overloaded the county is with work, but simply we don't have the resources to enforce anyway. But also the applicant has a pattern of violating and or operating in a way that completely disregards the neighborhood. They claim they don't rig and dereg bikes out there, but that has happened. They claim they don't maintain bikes and vehicles out there, but that has happened. They claim they don't have employees camping on that property, but that is happening. Those vans got moved out yesterday. But in addition to the commercial vehicles we saw today, which as I recall was 1 van, 2 commercial trucks, a trailer, and 3 cargo trailers. You have numerous employees coming and going because they're living on the property illegally. So the applicant does have a history of one, violating the code completely, disregarding county enforcement letters, disregarding county complaints, and disregarding what's in the best interest of the neighborhood. So given all that, mitigation is simply not a viable tool here. I think that's all I want to start with, but I'll hang out here if I may, and I might want to say, if you allow me.
Thank you. Mr. Cole, can I add just one point of information just for on that same topic? The applicant applied for the CUP, and there was also a pending complaint. The commission held off on resolving that complaint until the CUP process was completed. I just want that to be noted because that was one thing that the commission struggled with, and whether they were going to enforce it. The county kind of, at times, instead of seeking enforcement, they sometimes encourage individuals to apply and essentially ask for forgiveness. I think that's important to just note that sometimes the county has allowed a party that's theoretically violating to try to come into compliance that way. So that decision regarding the complaint, what should happen with that, hasn't been resolved yet. The complaints, it's true that Ms. Lund points out, the complaints have existed for a couple of years, and it's finally taken a bit of time to come to fruition where we have an application. And I know that's been a point of contention because those complaints, and what the county would point to is those complaints kind of give evidence of the fact that it hasn't just been peaceful in the neighborhood. There have been noise complaints, and those noise complaints have existed for a period of a year or so. And so that would point to the indication that the way in which the applicant is conducting the business is causing such discomfort to the neighborhood that they're taking the steps of actually going forward and filing, putting their name on it and processing it that way. So I just wanted to add those 2 points just to that.
Anyone else from the public who'd like to comment? Yes, sir. Please come forward and introduce yourself.
Right.
I'm Kevin Walker. I'm a county commissioner. I think Stephen covered a lot of the main points, but one thing I wanted to add is, when the commission was considering this, we didn't think about it in isolation. My understanding, from reading a law review articles of yours, Mr. Call, I think on conditional uses, is that the county needs to be consistent. And if in the future a similar conditional use application were to come up, and we had decided, say, to permit this one, then that makes us obligated, or certainly increases the odds that we're going to have to approve similar ones. We can't kind of pick and choose which ones to say, okay, we've got enough of this. And that's very relevant for us because this isn't occurring in isolation. I think the impacts of commercial activity, especially tourism-based commercial activity on residential neighborhoods in Grant County, is a very big issue for us over multiple years. Certainly, when I was running for election, I was saying, I'm going to protect neighborhoods. People are angry, and so we can't, even if we look at this one in isolation, we decide, impacts aren't so bad, we can handle it. Merrick's a nice guy, which he is, of course. We don't want to cause him grief. We need to look at, if we have a rule that this type of business is allowed in residential areas, we need to be, looking to the future where a lot of businesses are going to apply. There are a lot of guiding businesses in town. There are a lot of businesses that are similar to guiding businesses. Commercial real estate is expensive. Residential real estate is also expensive, but not quite as expensive as commercial real estate. So there's a very strong economic incentive for businesses like this to expand into residential areas. So I think that kind of larger picture, was important to our decision. So sorry, I probably said that in too many words.
Thank you. Any other comment? Yes, ma'am, please come forward. Yes, please.
My name is Trish Hadeen. I am a county commissioner, but I'm actually coming from, I live on Easy Street. And so from a neighborhood perspective, this is really disturbing. There has been quite a bit of disturbance to our neighborhood in the last year and a half or 2 years. It had, when this organization moved in, I will state that it had extreme impacts on my neighborhood. I started complaining pretty quickly, and what happened is they simply turned their traffic and started going down Chapman, which they still do. So unfortunately, Chapman started taking the hit. And So no matter what, those neighborhoods surrounding this, and I'll state that it goes out onto Spanish Valley Drive too. A lot of neighbors are affected, and a lot of neighbors have voiced that effect, and they're quite upset. I want to state that, and I've stated this quite a bit, I don't live in the city of Moab because I don't want to live in the city of Moab. I want to live in a more rural place within this county. I lived on Heather Lane for a while before I moved to Easy Street. I like the rural nature. I like the quiet. And I think we need to acknowledge that we have zoning in place just for that purpose, to give people solitude and refuge from the chaos that is our town now. And so I would like to maintain that. We are looking at a future land use plan in which we are, and Ms. Sloan spoke to this, we're acknowledging that we do need eventually to move commercialization out into the valley a little bit more, but we have indicated nodes that that's appropriate. Easy Street is not in that realm. And so, you know, our goal is to eventually provide more zoning for businesses and small businesses. But we're in that process, and we're actually not very far off from finishing that process. So to be spot zoning in this manner, which is what it is, I think is really inappropriate. And so thank you for hearing my comments. It's actually really scary to speak in public, you know, in this manner. Thank you.
Agreed.
Well, you'll certainly feel more sympathetic sitting in.
I
good seat.
know.
Thank you. Other comments? Seeing none, let's go back to the applicant and offer some response and perspective.
Thank you very much. As far as noise and dust, I feel like our operation creates much less noise and dust than local farming operations such as tractors tilling fields. I feel that we do not add to traffic. If we do, we add very little. It's not daily trips. Customers do not come to the property. It's multi-trips. In 2023, we ran 32 trips. That requires the vehicles to come and go twice, so 64 in total. Some of those trips were actually further away where they did multiple trips before coming back to the ranch as well. 20 parking spots, we didn't put that on our application because we need that much. We put that on there because the county required so many, but I also had this area of non-landscaped, and I thought it'd just look nice to fill that area on the plans as parking spots. And you saw today that there's probably 8 parking spots not being used by vehicles, as such as Bobcat, tractor, the trailers, my camper. I have 2 employees that own 2 vehicles and store them there. And I'd be happy to reduce the amount of parking spots on the plan if that made it better. We did do dust management. I brought in road base and packed that down to try to create less dust. I'd be happy to do more than that. We could get it sprayed with something that the county approves. I'm fine with our restrictions. My employees aren't so motivated that they want to work through the night. Sometimes they have to leave early, but they'd have to leave early for work if it wasn't a CUP. They'd still have to leave the house there at that time. But I'm fine with restrictions on rigging and de-rigging hours. That's completely fair. I have 1 person on site that is not an employee with us. He does not rent the entire house. He rents a room. The rest of the occupancy of that home is for employees as well as the ADU. There is concern of a lot of people camping in camper vans. Mountain bike guides are nomadic people. I provide housing for them, but they still have nomadic vehicles that are parked on site. They're not living in them. I provide shower and kitchen and beds. As far as disregarding the laws and rules and concerns of people, I feel that that is untrue. I did not originally in the beginning apply for a CUP because I didn't feel that it was necessary. I felt that it was employee housing and they were taking their company vehicles home and I was using the garage for some storage of things. As soon as it was brought to our attention by zoning, we started the application. I do think that that roadway should be measured. I believe it is 20 feet wide or wider. They mentioned the commercial horse boarding place at the end and the traffic that brings up and down the street of riding horses. If that commercial property is bringing horse traffic up and down the road, I don't think that should be one of the things that we're accountable for is for them. And the fence does surround the proposed area of the CUP. The proposed area of the CUP is just the back of the property, not the house in the front yard. That's what the county said they would require. It's just the back area, and the parking area and the garage to be fenced around. And I really don't think that we create a ton of noise. Chris that runs for us spoke and says that he barely notices us or hears us and he lives on site. But I do value the neighbors that's their home too and their concerns. And I want to do my best to be a good neighbor. And I hope that if there was ever a problem, they'd come to me and I'd do something about it. And I have that Bobcat when we had those minor floods. I went by and helped neighbor houses move sand back where it should be and dirts like that. We want to be good neighbors. But I think that's all I have.
Thank you. Any other thoughts before I start the conversation?
So, no, I was going to see if Mr. Call, if you'd like additional requests in the event that the decision hypothetically wasn't to deny the permit, if you wanted to hear conditions that we would be seeking, or if you want to continue the conversation, it's your discretion, of course. But I know that there were some things that both the party that was seeking to intervene had some concerns or some requests, and the county does too.
Thank you. Comment well placed. Yes, the threshold question is it eligible for approval as a conditional use? And then what conditions could be imposed that would be both reasonable and deal with the identified reasonably anticipated detrimental effects? Ms. Long, do you have a comment at this point?
I do, but I also want to respond to the vehicle trips, if I may first, to just
Sure.
close that discussion. The applicant both today and in the narrative with his application referenced 32 trips in 2023. It's April 16th. He has not ever told us what 2024 bookings look like. And obviously those could continue to grow through the year. But keep in mind that's 32 trips each way per vehicle. And also in the applicant narrative, there is an admission that there is pre-rigging activities. So oftentimes for security, those vehicles might go together to town and grab bikes and then come back and be stored the night before. And they especially do that when there is an early departure or a late re-arrival after a trip. So we are talking about at least, based on 2023 numbers, that would be 64 vehicle trips per vehicle. There are 4 commercial vehicles. And then you've got de-rigging, early pre-departure, late re-arrival where there's additional trips. In addition, we don't know 2024 numbers, but look at Moab. We grow and we grow and we grow and we grow. And that's one problem with the commercial use in a residential area is those numbers are only going to go up and they might exponentially go up from here. In terms of the conditions, it's my position that, again, as argued, that the impacts cannot be mitigated. I'm happy to talk about it, but in a clear way that any conditions would be arguing any alternative that I strongly believe, my clients strongly believe, based on the activity that's been on that property for the last 2 years and the matters we discussed today, that it cannot be mitigated, period. But if we, want to have a discussion in the alternative, I'm willing to do that today too.
Okay, thank you. Any other response to those limited comments?
Yeah, on that, for each of those trips, it's just one vehicle going out. It's not all the vehicles going out for a trip. For each trip, the vehicle goes into town the day before the tour, rigs, comes back. And then morning of the tour, it leaves, meets the customers. When it comes back for the tour, it stops at the car wash and it comes back. So it's 2 outs and ins per trip.
Okay,
I don't know if it would be helpful to, I mean, I'm assuming Mr. Call did, oh, well, actually, to be fair, we don't necessarily know what rigging is. I don't know what materials are put on. I don't know if going down that and exploring what all that entails is helpful. Rigging is different for each trip and operation. If we're adding or adjusting gearboxes or loading groceries, I don't know if that's helpful to the discussion or not.
well, let's not go there yet.
Can I add one more thing that I forgot? Sorry, I get nervous up here.
It's okay.
Oh shoot, I just forgot it. It was what Ms. Sloan was saying. 2024 numbers. Our numbers are actually going down quite a bit. 2021, 2022, after the pandemic, people wanted to travel like crazy, and our 2021 numbers were over double of what they are in 2019, and they're coming down back to normal right now. So our 2024 numbers as of this point are significantly less than 23.
Okay, so I will now pretend to think like a district court judge. And that's the job I have, is to try to keep the county out of court by trying to decide what a judge would do. And I must admit too much history with these kinds of issues. I serve on what's called the Land Use Task Force, and I have done that for 20 years. And that's where land use changes go to die, where proposals to improve the ordinances for the state statutes are thoroughly vetted by the League of Cities and Towns and the Association of Counties and what they call the Property Rights Coalition, which is basically home builders and developers. The ombudsman sits there, land use attorneys and planners from a variety of different jurisdictions. There's 30 or 40 of us that sit, argue against each other and try to stay friends anyway. And the language that's in this statute came through that process. This is what the meat grinder produced. And so I not only help write much of the language in the statutes, but I understand kind of where the legislature, that is, where the Land Use Task Force is coming from in terms of trying to balance the rights of individuals and the rights of communities and neighborhoods. So the challenge I face right here is best illustrated by this chart. This is the county's land use table, and it shows a variety of uses. And on this page, I've highlighted one square. This is principal uses in zoning districts. And in residential districts on this page, there's only one conditional use allowed. It's outdoor recreation. And on this page, residential uses in this area, there's only one conditional use allowed on this page. In rural residential area, outfitter, guide service and facility, non-ATV outfitter, guide service and rental business. So the problem I have, even though I sit in this august chair in these high chambers, is the county already said that use is desired in this zone. That the decision, I mean, theoretically, looking in the abstract, I shouldn't even worry about whether this use is desirable in the zone. The county said it was. And then the county said, if I'm wrong, please tell me. If you allow this use in this zone, it has to have an 8-foot fence, for example. Isn't that a county rule? So I can't say that having an 8-foot fence is outside of the county's, consistent with the county's ordinances plan when the county specifically requires it. And there are large areas of the county that are zoned rural residential. It makes all kinds of sense to me that the impression, the original idea was that there's lots of places, for example, along Spanish Valley Road, that might lend themselves to this. And that may be what they had in mind. But what the courts have said is when you're reading an ordinance, you read it assuming every word was carefully chosen. And that if anything's not there, it was specifically and consciously left out. And I know that makes hardly any sense at all to those of us who practice in the area. But if the county had intended for this to be only along arterial streets, it would have been easy to put in an asterisk and say in the rural residential zone, but only on an arterial street. So again, my job is to try to balance the interests of the property owner with the interests of the community and the ordinances, the county. But I'm stuck with the wording of the ordinance. That is, in this context, the county had a list of all the different kinds of uses that might be allowed and be consistent with their concept of the zone, and chose this one as the only one they thought was. Greenhouses are not, it says. So greenhouses and nursery, wholesale and retail are not desirable in this neighborhood. Certainly not ATV outfitters and guide services. But I'll soon stop rambling here. But the other concern I have is they didn't say rigging and staging for these uses. They allowed the full-blown use. That is, they're saying as a conditional use, bring the public here. This can be your home base. So again, back to the statute. We look at what the reasonably anticipated detrimental effects. I'm the only one in the state who knows those words by heart, surely. How do we, they don't have to be eliminated. And the county, when they chose this, and I'm no doubt it was all done by a group previous, that served in these chairs before the current occupants. But they knew what these uses involved. In other words, they wouldn't say, we want to have outfitters, guide services, and such facilities, but with no traffic. I mean, the commission, the council probably at the time, knew that they would generate traffic and they were still desirable in the area. And they knew that they would involve activities that could be different than what normal residential areas conduct or involve. And they said, all we're asking is when someone comes in for this as a proposed use, then impose reasonable conditions. And there's no question, this is clear, specific to the site, specific to the neighbors, anything that needs to be done. But you can't eliminate, you don't need to eliminate what the commission or council actually knew were fundamental parts of the business because they said that was desirable in the area. Now, having said that, let me give you an example of where I would consider it to be difficult. Let's say I want to build a gas station and I want to build it between a car wash and an auto parts store. I'm going to have a tough time being denied on my application for conditional use. But if I pick a location for a gas station and I want to do a 24-hour convenience store between a hospital and a nursing home, then I think the county can deny it. Because I don't think in that context, the normal things we associate with a 24-hour convenience store can be mitigated. Now let me comment for a minute on an interesting case, Staker versus Springdale. Because Ms. Sloan, in a very well written summary, thank you. I really appreciated the perspective offered there. In Staker, what was offered was a 83-car parking lot that was to be built within 20 feet of an existing house. And I don't, you guys probably know more about that when involved in Springdale than I would. But can you imagine living next to an 83-car parking lot where tourists come and go, heading up to Zion Park and back? It's court right at the entrance of Zion Park. All hours of the day and night, with families coming and going and packing and unpacking. And the irony of this is the Court of Appeals offered a split opinion. One of the judges said, I don't think we can support this denial. And the main thing I learned from the case was that judge criticized the applicant for not providing any evidence to support the approval. The neighbors, which the case rightly says, provided good evidence. I mean, certainly the neighbors were completely capable of providing credible opinions on what it means to have light shining in your windows in the middle of the night. And the noise, there was no mitigation, no 8-foot fence, nothing planned in the Staker case. And the property owner didn't offer anything to really mitigate in a way that was responsive to the neighbors. So in that 2-to-1 decision, the Court of Appeals said, yes, there's enough evidence to support this denial. And I appreciate the case and I've learned from it. By the way, the legislature changed the code again because it came up in the land use task force. And of course, the private side were not pleased with the result. They redefined what substantial evidence is after that. I don't know that that helps in our case. But anyway, this is my train of thought. This is where I come into the case and where I am. But I don't have a decision right now, but I would appreciate engaging in this conversation. So what thoughts do you have in the struggle that I would be expected to go through here?
I got some, but I defer the parties first.
Well, I guess the main thought is that, I mean, it is what the county seemed appropriate or deemed appropriate for land use of that area, and we were following that code for this application.
Stephen, do you want to-
Go ahead.
And your really well-written primer on CUPs, you yourself say that just because a CUP is allowed in an area by zoning, such as the land use table, then not every lot is appropriate for the conditional use permit. And that is why the county did adopt the criteria that we've been discussing, 9.10.5A through F. And when you look at those, that helps us determine that this is not appropriate. And some other interesting facts from the Springdale case that I think are relevant here is a lot of the actual location specifics that the court relied on, not just the town relied on, but then the court relied on to uphold the denial. And those are the placement of a commercial use within an existing residential subdivision, such as we have here. Also, the existence of 2-story homes in particular that would be looking down into the use. And even though a fence was not required or discussed at length by the town, I do think there was discussion in the case about a fence, and it wasn't sufficient because there are 2-story homes looking down on the use. They would just be looking right over a fence, and you have that here. Eric Flume, who lives just behind this, has a 2-story home looking into this backyard, and he's on that backyard side. He's on the parking lot side of this property. The other good facts that the court relied on was the distance of the existing residential homes. And they cited to distances, and we have homes just as close, if not closer, specifically the one off that northwest side. And I believe there's one more just straight behind, exactly sort of westish versus Eric Flume, who is, directions more southerly, that are 20-25 feet away. So those facts are also good, especially when you're looking at the standards in the land use code for showing that on this particular lot, use is not appropriate.
Those homes are more than 20 feet away because I put them in, I built the decks for them, and I had to run 2 different 100-foot cords from that shed to reach the one place and more to reach the other.
Well, without objection, I'm happy to go to Google Earth and measure to get a sense of it, but please go ahead.
Digging further, although it's a permitted use regarding the outfitter, it doesn't mean that every single outfit or guide service and facility will be permitted. We need to look at the particular parcel. We need to look at the particular actor. Here, what's concerning to the county is that this actor previously has not conducted itself in a manner that has been complaint free. And so
The
although
problem
it's,
I have, council, is that's not one of the criteria. The criteria that in the ordinance doesn't mention the past action or activity of the applicant as a criteria.
well, it demonstrates the evidence of whether it's compatible with the environment, with the peaceful enjoyment of the parcels adjacent to that.
Well, I don't know how to do that, but the case I'm thinking of is, Uinta Mountain Homes versus Duchesne County. The county commission turned down a conditional use because the applicant in his testimony said if he didn't have 15 boys in his group home, he wouldn't make it. Isn't financially feasible. And the county commission said, well, we don't have to approve something that's not feasible. The county commission limited you to 10 boys. We're turning it down because it's not feasible. And the Court of Appeals said feasibility is not one of the standards in the ordinance. You didn't list that in the standards. So again, I'm trying to make this conversation, not sure, argue, but that's my impression is that, and another case that comes to mind involves a gravel plant on the railroad in Summit County, right at Echo. There's a rock crushing facility right by the railroad, and next door is this house. And the people in the house sued, and the Court of Appeals said, yes, he should have got a building permit, but go ahead and get one. So maybe not what I would have done or you would have done, but the courts have said basically your past conduct isn't an issue. If you qualify for a building permit, you're entitled to get one.
Right. What my position would be is that we're stating, although not necessarily the violation is prohibiting the action moving forward, instead it's indicative of the evidence that they are not compatible with the surrounding area, that the noise is exceeding the standard amount that's causing the complaint. Not that we would just provide a blanket denial just because there have been complaints, but it's part of the analysis would be that.
And again, help me that, and I'm honest, I'm playing devil's advocate part. I really am not sure where to go with this, but I mean, ranches aren't quiet. I mean, I noticed the presence of the bobcat there. I mean, people in rural areas have tractors and equipment and move them around, and the point's well taken that the process of running a farm is going to create some dust and noise, and goodness knows some people have moved into the area and have no idea what time you harvest hay in order to make sure it comes in before the weather turns. So it's not necessarily conclusive for me to look at only issues of noise and dust in an area that has other activities and other areas. I drove around the area, I certainly saw plenty of homes that had a lot of vehicles stored and were used on the property. The applicants made a good point of commenting on how many trips a family can create in terms of traffic in a given day. I'm just thinking out loud and asking for your help to go through this process. Yes, sir, you're welcome to step back up to the mic and comment. It's Mr. Walker.
Yeah, I just wanted to elaborate on some things Stephen said, which I agree with. And 2 points. One, the one you were just talking about. It is. I think you made some very good points on these determinations about how much noise is too much noise. I mean that it's not like measuring whether a setback is 20 feet or only 18. It's hard to do that. But let's imagine that we had an unlimited budget and we wanted to study the question. We could say, well, let's take in some neighborhood, let's put a use very similar to the one being proposed and let it operate for a couple of years. And then, we could try to then measure the noise with decibel meters, but, we don't really know what the base background is. So let's just see if it generates a lot of complaints. And if it does, then I think if I were a scientist and I'm trying to get the best possible answer, does this type of activity in this type of neighborhood, cause excess noise, I would do the experiment. And then my point is, of course, is that we have done the experiment because this was you know, we're talking about the past as well as the future here. This did operate in that neighborhood for a year and a half or 2 years, and it did generate complaints. And I know when I was on the county commission, you know, how many vehicle trips is too much? That's a tough question. But, you know, we have various businesses, some legal, some not, operating in neighborhoods. Only a handful generate a large number of complaints. And so to me, it was striking that this one did generate a significant number of complaints. I don't live out there. I didn't observe it firsthand, but that's what, you know, gave me confidence to vote the way I did. The second thing I wanted to address something you said a moment ago. You know, you were pointing to this conditional use existing in the use table, and the people who drafted the use table must have had something in mind. I don't know exactly where it dates, but I was probably on the planning commission when that part of the land use code was finalized, and certainly we've made similar decisions since we're on the county commission. And I think we all can agree that, you know, outfitting and guide business, that describes a very wide variety of businesses. You know, some of them might use a lot of vehicles, some not at all, some might involve rigging, some might involve not at all. So that it's a pretty wide spectrum of business types. And then the rural residential zone is actually notoriously diverse within our county. This came up a few years ago when we were talking about putting some kind of, you know, alternative housing and which zones it might be appropriate for. And there was a long and detailed debate on the county commission about whether it would be appropriate to add the rural residential zone as one of the zones where it was permitted. And the key fact people put up is in Grand County, the rural residential zone is kind of a catch-all zone. It encompasses a big, you know, some of it's relatively densely, you know, you can find just on the south side of town, you know, fairly dense housing that's in rural residential zone. Some is quite dense, some is really close to highway or other noise, you know, some are almost semi-industrial. And so what we said at that thing is that, you know, yes, we can think of lots of rural residential zones where this type of housing would not be appropriate. We wanted to keep open the option of allowing it on, you know, maybe a minority of rural residential parcels where it would be appropriate. And so you know, in this, you know, separate decision process where we discussed that in detail, you know, we put it in there, but the idea was it would be appropriate, you know, some small fraction of the time, but enough that we wanted to leave that option open. And I think something similar went on with that being in the use table. You know, can I think of an outfitting and guide business and a rural residential area that would be a good match? Yeah, I can think of places like, you know, the combination, you know, it's like a matrix, you know, businesses types this way and, you know, neighborhood types that way. It can happen, but I can also easily think of situations like the current one where I think it isn't appropriate. So
I do want to clarify that when Commissioner Walker talks about diversity in rural residential, it's along Spanish Valley Drive, Arterial Collector Road. And the high density workforce housing projects he's talking about were along major roads in the county, namely Spanish Valley Drive, and those did require rezones. So it wasn't allowed in rural residential per se. So it's a much more complex thing. And rural residential in this area is not diverse. It is rural. It is supposed to be country. And when you go back to the general plan, and I did cite in my letter some specific sections, there are a ton more than what I even cited to. But for example, and I'm all citing to the 2022 general plan that was recently adopted, section 3.5, talks about neighborhoods, residential neighborhoods. 5.1, small town feel, also livable community. 5.3, stewardship and neighborhoods. 5.4, community safety and neighborhoods. 6.1, preservation of residential neighborhoods. 6.3.1.3, enhancement of historic neighborhood character. 6.4.2, county residential land. 6.4.3.1, country residential. And so your example, Mr. Call, when you were talking about the ag uses, you know, that has long been not just acceptable in this area, but desired. We get behind a tractor going 3 miles per hour in our hearts. So we're just so happy to be there. Just like Ms. Hadeen mentioned, she sought this out. That is what that neighborhood is for. It's extremely different from Moab's tourism sector moving into rural residential on Easy Street. That is, you know, just worlds apart from each other. And not just the heart feel of it, but the actual noise is very different. It really is.
So Sammy,
I just
Please go right ahead.
I think this may have misunderstood the point I was making, because I think I agree with her. You know, there are rural residential zone parcels along these major collector roads. And the county tends to treat those differently than the parcels with identical zoning, but in quieter parts of the county further away. You know, it's something, and for us to treat those, you know, we could make a zoning table with, 97 different zones. But instead, we just make certain uses conditional, and when the application comes up, we decide, is this an area that's already got a fair amount of traffic, or is it an area that doesn't? That's the kind of speaking.
I didn't misunderstand. I just wanted to flesh out what.
And may I add to that a little?
Oh, yes, please.
They did approve a denser home for community rebuilds, those 4 homes just kitty corner across the street. They did change that rule to allow those homes to be built, those 4 homes that are on 1/4 acre lots, I believe. And I believe also a lot of the noise and traffic complaints against us over the last 2 years were just assimilated with us because of 5 homes being built, and the contractors drove in and out for lunch and to work in the morning and home everything. They drove fast and they were noisy. And I'm just worried that a lot of those complaints were relating them to us. That was actually
short strokes.
sorry, and that wasn't including those 4 homes. So in total 9 homes.
So help me understand, what is the noise? What generates the noise, at least in the impression of those that are concerned about it? Is it just voices being raised, just people talk to each other when they're loading sleeping bags and equipment into the vans? Or is
Well,
there?
Well, there's two aspects of noise. One along the roadway, which is noise being generated from these larger vehicles and trailers. And then not just larger vehicles and trailers, but larger vehicles and trailers weighted down with all the stuff. Once they rig the bikes in town and they bring the bikes back, all that is just bouncing and noisy in a different way than normal. There's been speed concerns, there's been music concerns of the employees driving those vehicles. Yes, there's residential road trips happening, but these are different traffic vehicle noises. And then yes, on property, and I think Commissioner Hadeen can also specifically speak to this, but what my clients tell me is that there is often a lot of people on the property. Today was very quiet. There wasn't a lot going on. There's numerous vehicles, there's numerous commercial vehicles, there's gear everywhere, there's maintenance going on. Often they figure out an issue with a piece of equipment or a bike or a vehicle, and they're maintaining all that stuff right there. There's hazardous material concerns, which also brought up in my letter. So like in the Springdale case, it's not just noise, because, you can have a big family and wow, they make a ton of noise. It's a different kind of noise. It's a commercial kind of noise that is happening on that property, especially given that, again, it's not a commercial use. It's incidental to an owner being there. It's something very different.
I think one other element of the noise is, if you look at this parcel, it's a unique parcel. It's a flagship lot where it has that road that goes all the way. It's not just adjacent to the street. Instead, you have to go down through that little road that brings you back kind of more into the heart of the residential area. And I think where you may look and say, well, it's on the conditional use table and we anticipate that there's some noise. I think the unique characteristics of the parcel create another element to this, where you have all that noise being brought back into the center, or brought back more into the neighborhood, as opposed to if it was just merely on the street. And so I think that's a unique aspect of it. It's rigging, it's de-rigging, and then it's the number of people. But specifically, I think individuals could individuals in the community have reported that there's odd hours that the noise is at, and that's the other concern that they've had, is that early morning trips, rigging and de-rigging it at later hours.
Trying to decide what I saw this morning that is involved in that would make a lot of noise when it was transferred into a van.
Well, maybe applicant, one concern I've heard too is, okay, they're de-rigging after a trip. Everything is dirty. I get that the vehicles go back to car wash, but how do you handle, when you're de-rigging a van after a trip, how do you handle all the dirt and mess that is in everything?
The tents and stuff like that,
Yeah.
washing tents.
Yeah, and I saw a washer dryer in there, but Yeah, and cook stoves and all of it.
Yep. I mean, it's standard stuff where like if a family took their camping gear camping, we washed pillowcases in the washer and dryer, and sleeping bag liners and stuff like that. The cook stoves, so they don't get that dirty. They clean them daily. We're not like coming back from trips with things covered in grease. They're cleaning them while they're out there. It's basically just washing some dishes if they got dusty, being in crates, and then doing laundry. And then the bulk of the dirt is on the vehicle. That means everything else is contained inside of stuff. So that gets washed off at the car wash it down.
You take everything out, open it up, make sure it's clean. What happens after, let's say you guys got in a big rain, do you open everything up, dry it out? Yeah, there's a lot to that. It doesn't just happen in that garage. They're taking everything out, all this equipment. It's a lot to service one of these trips, and they're opening everything up, making sure it's clean, cleaning it when they need to, maintaining when they need to, drying things when they need to, and then they're collapsing everything down and putting it back neatly into the neat garage we saw today. But that's just not reality of what that property out there looks like.
How many pounds of equipment do you think each trip brings?
The
Or
equipment's
you guys-
pretty light. The weight is water, hauling potable water over the tour. If it was just our kitchen gear and like chairs and tents and stuff, I'd say 500 pounds. That's just a rough estimate.
So you're loading 500 pounds on, unloading it. How many people does it take to load and unload?
You can do it by yourself. But all my employees work in teams of 2.
Okay. Well, I think I've heard what I need to hear. Happy to provide any more comment, but I've got to ponder this one. Can't make an announcement on the spot. Any other parting thoughts or messages as I take this under advisement?
No, do you have an estimated time frame for when you might decide?
Sure, no longer than a week. And if it looks to me like well, let me again give you a little stream of consciousness. It really helped me, what Commissioner Walker said about the intent involved in putting this in the code, because the planning commission and the county council or commission at the time may have had the impression that it's, we can take it or leave it. If we allow it, we can not allow it. The problem is, of course, the state legislature had a different way of dealing with this same words we're dealing with. But we have, we didn't have a case where conditional use denial was upheld before the Staker case. So it really helps. Well, actually it hurts. But, there's no knee-jerk reaction. These are very site specific, and you've been very helpful and come up with, I think, 100% relevant information. I mean, we haven't gone off on tangents and focused on exactly what matters here. So that's very helpful. But within a week, I'll announce a decision as to whether or not to grant the use. And if I decide we are obligated under the law to grant it, then we'll start another round and we'll talk about conditions. I am hardly qualified to represent the interests of all the community, but that's the job I've been appointed to. And so the goal, if we have to get into the issue of interest or conditions, is to mediate it rather than arbitrate it, to try to negotiate something that sounds reasonable and is consistent with the county's code and rules. But again, I don't know whether we'll get there or not. So, thank you very much. It's 11:25 in the morning. We've been here 5 minutes. I appreciate the courtesy and the quality of the conversation. It's been very helpful. And I will officially take the matter under advisement and make a decision on the preliminary issue, whether the conditional use, whether it appears to me that the reasonably anticipated detrimental effects of this use in this location can be mitigated. If they are, then the use must be issued. If they in fact cannot, then that will end it, and I'll prepare an opinion to that effect. Thank you.
Thank you.
Thank you.
You.